Good afternoon, everyone, and welcome to today's presentation, Public Accommodations and Employment Law 101 for the Service Industry. Our presenters today are Brett Miller, a shareholder here at Butzel, and Hannah Treppa, an associate here at Butzel. Before we begin the presentation, I want to take care of some housekeeping. Please feel free to ask any questions during the presentation using the question panel in GoToWebinar. Our presenters will answer your questions at the end of the presentation, time permitting. So with that, I'd like to introduce Brett Miller and Hannah Treppa.
Thank you, John. Hannah and I today will be talking about sort of a high-level overview of some of the key laws that relate to public accommodations and in employment laws as well for the service industry. So public accommodations in Section 1, we'll be discussing patrons, vendors, customer-facing employees who have to deal with the public, what those laws are and what it means for employees and managers who are frequently engaged in customer interactions. We'll go through some do's and don'ts, and we're focusing on Michigan law for Michigan employers, looking at the Elliott-Larsen Civil Rights Act. It's going to be abbreviated as ELCRA in the slides. And in part 2, we're going to discuss some of the key provisions and laws that govern workplace anti-harassment, anti-discrimination policies, and some of these issues that really crop up for service industry employees and managers. And Hannah, we've seen some cases recently and some hot topics revolving around actual public accommodations. And what are some of the do's and don'ts we see in that area?
All right, well, let's first talk about, why is this important? So, of course, we want to avoid liability for the company and also potential liability for oneself. And most importantly, to just ensure that complaints are appropriately reported, investigated, and addressed, and just establish the best practices for a healthy work environment. Most often, when we think of illegal discrimination, I think most people think of it in the employment context, which of course is discriminating on against someone when you're selecting them for a position or basing an employment decision on a protected characteristic. But it's also, of course, discrimination or segregation in a place of public accommodation based on those same protected characteristics. Brett, can you talk a little bit about what a public accommodation is?
Well, that's a great point, Anna. There's lots of legalese involved in public accommodation. We see on the slides we have definitions from both Michigan and federal law, but the takeaway here is that when we're talking about public accommodation, we're talking about services, goods, anything sold or available generally to the public. It's going to apply in the service industry most often. We're talking about restaurants, bars, malls, stores, healthcare facilities, hospitals, hotels are covered. Anything that where you have the public coming in, you have vendors coming in, and there's specific laws that we call public accommodations. And so those services or goods that are, in other words, available to the public. And the key takeaway here is that the public accommodation is designed to have equal access. Everyone should be entitled to the full enjoyment of those goods, services, facilities, and the equal opportunity really. Sometimes people think of this in a disability context. Wheelchair access. Is there a wheelchair ramp or an elevator? But it goes pretty far beyond that. We have seen recent cases that go beyond, handicap ramps or wheelchair access and into things like service animals who want to come into a restaurant. And, there's questions of who can access or who can bring a dog in, for instance, or what questions can someone ask if someone brings a service animal in? And there's kind of obvious cases where someone comes in with a cane and has a leader dog from the blind. That's a pretty much a no-brainer. But
right.
When people want to bring their pet, pit bull in and mosey up to the bar, it can be a different question. So just a few takeaways on that. If you have a service animal question, or issue in the employment context or for your employees, there's some questions you can ask, like, is this a service animal required because of a disability? And you can ask what tasks or work the animal's been trained to perform. The law really talks about dogs and, of all things, miniature horses, but you people coming in with their cat on a leash or something is not going to be something that you have to really honor. But you can ask these questions to get a better sense of whether this is somebody's pet or real service animal. Things not to ask.
Right.
Don't ask the specifics of a disability. If someone says, I have this service animal because of a disability, you don't say, well, are you blind? Are you deaf? Tell me about, you can't go into those details. You can't ask them for medical documentation or an ID card. I will note that the Michigan Department of Civil Rights now has a program where people can register their service animals and get a big patch that's kind of an easy way to identify if it's a legit service animal. But you also can't ask for that, proof or any kind of training documents. Again, you can ask, has the dog been trained for a task, but you can't say, show me all your proof of that. So this is just something else we see in kind of this equal context issue. And practically speaking, we also have issues with guests, patrons, customers, and employees and managers should have policies in place and be trained to know, okay, what can they do, what can't they do, what's protected, what isn't protected. Most companies have pretty detailed equal employment opportunity policies that set forth all of the employment protected categories, but they don't think about it for a customer walking in. And it's much the same for what you see in employment context. Religion, race, color, national origin, age, marital status are all protected under that Michigan law, the Elliott-Larsen Civil Rights Act, and of course also protected under federal law. So these things, again, basically means you have to be treating people equally and fairly based on these protected categories. You can't say, you know what, we're going to discriminate against people who have headscarves and who happen to be Muslim, or based on someone's race. You have to allow everyone equal access to the services or goods your company provides. And there's been some examples of how this leads to lawsuits. Well, 10 years ago, there was a big case with a hotel, again, which is an entity available for public accommodation. And essentially, it was an African-American couple who wanted to get married at this hotel. They couldn't get any kind of callback from the wedding planner or the hotel. They were offering to put down money to pay a minimum for their wedding, and expenses. The guarantee $12,000 would be paid, and their claim was that no one would call them back, and yet Caucasian couples were being booked left and right and getting callbacks. So it's an example of, in that case, of course, there's two sides of every story, but in that case, the allegations were that this was unfair treatment for this public accommodation based on their race. And some takeaways there. I mean, in the allegation that the wedding planner is not calling back, does your company have some kind of procedure that someone could contact someone else? Does the wedding planner have the ability to report to someone else that she's having some kind of issues with the customer, so that there's no dispute down the line as to why someone was contacted, why someone was let in? Some of these sort of low-hanging fruit that can be addressed by companies through policies and procedures can go a long way. In the hospital context, there's been many lawsuits regarding alleged, for instance, racist patients. We had or patients who have some kind of prejudice. We defended a case early in my career where a patient refused to have any Filipino nurses help him. There's been cases where someone wouldn't accept treatment from an African American physician. I mean, these cases kind of cross over both the public accommodation and employment context, Hannah, because you can't choose to staff your company based on a vendor or third party's preferences. And
Right.
if someone has a racist view, you can't honor that and then take an adverse action against an employee. In the same time, you have to communicate to that customer or patient that their views or their position cannot be honored, and you can cite these laws. It's simply illegal. Real estate. This is something that comes up for real estate agents. We've had cases with alleged racial steering. I had a case years ago where a real estate group was accused of showing African American employees homes in the Detroit area on the border of Grosse Pointe, and any white customer who came in, they would show homes in Grosse Pointe. And they were claiming that this was steering to someone based on the perceived, demographics of the neighborhood. And what happens in those cases are people send in, nonprofit groups will send in testers, someone who says, I'm a Caucasian person, where will you show me a house, real estate person? If they get to go to Grosse Pointe, and an African American tester comes in later, asks the same question, and they're shown a house in Detroit, they might have a lawsuit, and they bring those cases. So these are some examples of how these can play out in practice. There was also a big matter in the news a few years ago with a local bar who had asked a group of African American women to move from the bar area to a side area after they had been, over 20 minutes without, ordering any food, drinking. Their meal was done. It was a busy night. Policy was to kind of make sure you can move the tables. And that group took offense and claimed that they were being picked on based on their race. And even if there's, a policy in place, there were other African American patrons in the restaurant that night. There were Caucasian people who had been asked to move. If they were delaying too long, there's the optics there. There's the issue that it can become, a customer can become irate or be perceived that they're being treated unfairly. And it can lead to potential litigation. That case was before the Michigan Department of Civil Rights, a state agency. But again, you can see how these issues can really escalate if people feel they're being treated unfairly.
Sure.
And that's where we have, policies and procedures, things that you as an employer or as an employee of a company can do. Obviously, you don't want to stereotype. Some of the stuff is pretty basic, but it also applies that if you see someone else engaging in this conduct, that you can put a stop to it. You don't want your friends, colleagues, coworkers to be treating people unfairly or in a particular manner. You're not going to keep silent or fail to report if you see something going on that someone's being banned from a premises because of these characteristics we've talked about. And you don't want to assume that someone else is responsible if you have the ability to report something. You need to speak up. If you're a manager, you're going to have a legal duty to take some action. So those are some don'ts. Of course, do's are, take suggestions from customers and complaints seriously. Sometimes when you're in a public context, the initial report may just be a customer service issue. People won't think that it's about race or religion or these protected categories. But, a manager who knows these policies can take it seriously and take steps to address it. And it's up to the employees as well, not just managers, to be responsible for these behaviors, to be inclusive, to treat everyone fairly. We've mentioned company procedures and policies. If the company has rules in place on how to report, and which they should, those procedures should be followed. Follow up with complaints, report anything to a manager, and make sure that those procedures are in place so everyone can feel comfortable and everyone knows what to do.
Well, and Brett, of course, a lot of companies and employers have policies about employee reporting, but is it a good idea to have a policy or procedure in place for customer reporting? Can you talk a little bit about that?
Absolutely. I think that's a key provision because you're right, it's often ignored. People think about a sexual harassment policy and who do you report to, but when you have customer concerns, is there some outlet for that customer? Often it's, let me talk to the manager. Is your manager trained on how to deal with these things? Does the manager know the policies? And often, if customers or patrons feel they're not getting anywhere with the manager, that's when you can suddenly see some escalation. That was exactly what happened in the case I mentioned with the bar, where the group of African American women were sort of asked to go to the side table, and it escalated when they felt that they weren't getting anywhere with the manager. There's ways to handle that, right? Complaint forms. Is there some hotline? Is there some place else that you can send a customer to go to report their grievance and that can diffuse the situation?
Making sure that the manager on duty knows that they have the authority to allow people to stay or to override the decision of the employee who may have denied access or asked someone to leave.
Yeah, and absolutely. And in cases where there's some kind of blatant issue going on, the manager's going to have a duty to fix it. But in cases where it's, often where the company's done nothing wrong, but the customer is perhaps not getting the result he or she wants, and maybe now raising some issue of race, religion, or some kind of bias, that's when you want to have some outlet, some relief valve in place for that customer. We recommend complaint forms. We have forms that we provide to clients that give the ability for the manager or employee can hand out, say, if you have concerns, please fill this form out, call this number, do whatever that can that diffuses the situation, lets that customer think about it, cool down, and if they need to file a complaint, you'll have something at that point that can be detailed and investigated down the line. Because sometimes in the heat of a moment at a busy night at a bar, for instance, is the manager going to stop everything and do a formal written investigation of some event? Probably not. But there are steps that you can take to make sure that the customer feels that his or her concerns are addressed. The company then can take on the protection from liability to have a written policy in place with a documented investigation to make sure that they are protecting themselves, and employees, frankly, are protecting their jobs because they don't want to be accused of any kind of wrongful bias. So, and from an employment standpoint, there are a lot of rules that also govern the workplace in addition to these public accommodation issues.
So we're going to move into sort of a 101 anti-discrimination, anti-harassment training for both managers and employees. Of course, there are all kinds of laws and regulations that might apply dependent upon the field, medical field, restaurant. But we wanted to highlight here the major statutes that we see at issue most often. Of course, Title VII, ADA, ADEA, Equal Pay Act, and all prohibit discrimination based upon the protected characteristics and retaliation for reporting any violations of these laws. Most of these laws are designed to protect against discrimination based on these categories: age, sex, gender, religion, race, color, disability, and so on, national origin, pregnancy and veteran status, and genetic information as well. The EEOC and the MDCR have been accepting charges really for years, despite a legal debate over whether sexual orientation, gender identity, gender expression are protected categories. But there are lots of ordinances that cover those protected categories, and we recommend that as a best practice, your policies include a prohibition of discrimination based on sexual orientation, gender identity, and gender expression.
Yeah, that's a great point. In different states, if a company has locations in different states, have different rules. As you mentioned, different cities have different rules on this. Detroit, for instance, has in its charter LGBTQ protection. Ann Arbor, Ferndale, there's numerous cities where if a company is located, they would have to have this policy anyway. So it's certainly a best practice, as you mentioned, to include that protection and make sure that those policies and people are trained on that.
Right. So let's talk a little bit about workplace harassment. So the legal standard, as you can see there, is whether the harassment is so severe and pervasive that it unreasonably interferes with an employee's ability to work effectively. Factors that determine whether harassment exists, it's a question of fact every time, but it's really whether a reasonable person would be offended by this conduct. And the courts will look at things like frequency and severity of the conduct, whether it was physically threatening. The hostile work environment standard can take many forms, and it's not just the sexual harassment that we hear about in the news so frequently. Brett, can you talk a little bit about the other types of illegal harassment?
Well, there are many types of harassment, Hannah. You mentioned a few. And one on the slide you mentioned go back to the last slide, an isolated or ambiguous comment. I wanted to talk about that because you're right. Sexual harassment is one thing, but any kind of hostile work environment, from a legal standpoint, an isolated or ambiguous comment, we're kind of quoting from the law, is not going to usually rise to the level of hostile work environment. But if you're at a manager or an HR person and you're dealing with alleged claims, you need to treat everything pretty seriously, report it up, and do the investigation. Because sometimes, as a matter of law, depending on how bad that comment is, it could lead to liability. A racial slur, particularly in the context of an adverse employment action, is going to be a
Absolutely.
major problem. And this also applies to religious harassment, national origin discrimination, disability, age, any of these protected categories. I mean, we even put color on here. I mean, Hannah and I we just had that case dismissed that involved a claim of color harassment. In other words, it was a African American employee who claimed that he was discriminated against because he had a lighter complexion, and he had the same complexion as his manager, but was claiming that was somehow treated unfairly. And the case was dismissed, but it's an example that's a claim. People can sue for any of these categories, even if it's something that people don't always think about when they're talking about the harassment policies and worrying about sexual harassment or the things that are really in the news. Yeah. There's broad categories of coverage here. And it takes many forms, right? I mean, we've seen cases with verbal harassment, you mentioned. Like we said, an isolated comment that's a racial epithet may be a very bad thing in terms of from immediate legal liability. Negative stereotypes, jokes, pranks are all forms of verbal harassment that should be investigated thoroughly. Employers have a duty to take prompt remedial measures when they're on notice of this type of harassment. It's not always just that there's some kind of physical harassment, which is certainly a category, but it's also written. Poems, letters, cartoons, little notes left around a workplace, anything that denigrates or shows hostility to one of these protected categories can all rise to the level of a hostile work environment when it hits that severity. So, what do you need to know to avoid harassment? Well, I mean, one thing is training like this, policies and procedures on how to act so others know the rules, know the policy, know the reporting, and the actions that should be taken if someone is claiming to be a victim of harassment, or if they do feel uncomfortable in the workplace. What are the outlets? Do they have some policy that says, I go directly to my manager? If my manager doesn't do anything, I get to go to HR. These are things that should be clearly spelled out. I've had lawsuits that we had problems with because the phone number of the person to contact wasn't listed, and people claimed they couldn't get a hold of anyone. So these are a few things that employers certainly should know, and again, that policies would govern.
Well, and a lot of times too, I think in these situations, employees and managers are aware of what might constitute extreme harassment, but there are certainly situations that are just sort of uncomfortable conversations, or people feel uncomfortable and they don't know really what to do about it. And a lot of times we advise first letting the person know who's making you feel uncomfortable that they've made you uncomfortable. That's certainly not the only way to address it, but certainly a place to start.
Well, and that's a great point, because there are issues in the workplace that aren't always so clear cut, right? There's sort of the thin ice, what we call thin ice kind of comments of, is there some kind of touching in an offensive manner, but one person doesn't realize it's offensive? Everybody has the hugger in the office, or the person who just maybe is a little a close talker, or someone who puts their hand on people's shoulder, maybe a little uncomfortably, and people don't always like it. But is the person engaging in intentional hostile work environment, or is it a simple conversation? Hey, remember when you were touching Susan's back the other day? She really didn't appreciate that. We need you to maintain some personal space. I mean, sometimes these things are pretty easy, but if allowed to go sort of unaddressed, they can become potentially, that prohibited conduct that rises to a higher level. And I mean, it can be compliments about a person's body or physical appearance, and I hear that sometimes people say, oh, I can compliment that pretty young lady, I'm harmless. Like, well, she might not think so. So there needs to be some training and policies in place, even in terms of endearment, dear, angel, things like that from one person may think, oh, I talk to everybody like this, but it's making someone uncomfortable. I mean, from an employment standpoint, you don't really want to have the equal opportunity offender walking around in your workplace, because if one person takes it, it's just, oh, Bob being Bob. That's usually a bad sign if it's something that's is making people uncomfortable. And I mentioned like the close talkers. Personal space is a big one. Obviously, you get into a little more severe stuff with asking someone out, wanting to get drinks or dates, and it's being rebuffed, and it continues. Sometimes shop talk can get a little inappropriate, unprofessional. A lot of times you don't have someone really claim immediately that they're offended, but you know what? It should be sort of banned to begin with so that you don't have that thin ice kind of concern. We also see these days a lot of issues outside the workplace. Okay, so emails and texts are the biggest offenders. I mean, even an emoji can be considered a bit harassing, and we've left the some of the more offensive emojis off. You know, there's no eggplant on this slide, but you'll be surprised what you see people sending to each other by text. And if anybody wants to know what offensive emojis are out there, you can certainly Google it, and there'll be a whole list. But there are ways to have these concerns outside of the workplace with phone calls, texts, chats, and the same rules should apply. Employees should know that they can report these things. There are terms and communications that people don't even really think about sometimes that could be offensive. You know, Hannah, we had that case recently where the phrase "bye Felicia," which is a pop culture phrase that a lot of people, at least of a certain generation, would know, was accused to be a racist statement, where most people would say, no, that's just a movie quote, and everybody knows what that means. It has nothing to do with race. But you never know, you see, and sometimes these things need to be addressed in the workplace, and before you see problems. And you know, those are just a few examples, but there are many other ways that people can be harassed.
Absolutely. You know, sometimes we get a laugh when we mention the example of poems or letters. People tend to giggle at that, but really, there are a lot of different forms we've seen this come in, and a lot of times I think people think that this starts as joking, you know, and they'll feel like the person that they've made a comment in front of or said something to didn't react in a way that let them know that they were offended by it. Maybe they giggled, maybe they just kind of brushed it off. But a lot of times people don't feel comfortable speaking up in a situation where they do feel uncomfortable. And so sometimes when you receive that giggling response, it doesn't necessarily mean that it's a free pass and that someone feels comfortable with what you've said to them or what's being discussed in a room.
Right, and managers need to be trained in those circumstances, that you don't necessarily just wait for that report, because if the comment itself, whether it's giggle response, kind of violates policy or seems to be beyond crossing a line, the manager needs to step in before it gets worse and someone comes to them.
Absolutely. Well, and in today's world, social media, text, chat rooms, things like that, that's becoming a huge issue. And we often have clients, I know, ask about how they can get access to social media accounts or how they can see what's going on with these employees. And Brett, do you want to talk a little bit about that?
That's a great point. We get this all the time. Someone says, so-and-so outside of work has made a threat or is harassing me or something like that. And for whatever reason, some managers suddenly say, well, give me your password. I want to go in and look at your Facebook account because it's a private account and you're friends with this person, and I'll get to the bottom of this. Don't ask for passwords. Don't go to the alleged offender and ask for their password. The way to handle this with social media or text message, take a screenshot of it, give me the copy of the screenshot, we can print it out, we can do an investigation, we can put that in the investigative file. No one's getting access to anybody's account, but you're getting the actual, offending image brought to you as a manager, HR professional, and you can conduct your investigation. But yeah, passwords are a no-no.
And so we kind of already talked about this a little bit, but the unacceptable excuses for conduct. It's important that employees are aware of this. We talked about, they never objected before. I thought it was okay. The giggling, the response where, you might not have someone who feels comfortable responding to them with, you've made me uncomfortable.
Yeah, these are the most common things you'll see in a harassment investigation. It was just a joke, or like I said, the person thinks it's harmless, or they're so stressed out, it was a hectic day at work, and they made some angry comment that could be construed as threatening. I mean, these are not excuses. You certainly would take down whatever their, quote unquote, explanation is in a investigation, but don't excuse it. And we see this all the time with people in interracial groups, for instance, making a comment, but we so-and-so joked like that all the time. Well, obviously not, because it's now become an investigation. So you'll see these commonly, but they're not excuses.
And so let's talk a little bit about reporting. Of course, all the statutes we've discussed are prohibit retaliation. So just as one can't be discriminated against based upon their protective status, they certainly can't be retaliated against for engaging in a complaint regarding any discrimination. And this is where it's really important that the management understands their responsibilities. So first and foremost, your managers really need to know your company's policy and how these kind of complaints are reported, investigated internally, and just what their response and their dealings need to be with these kind of complaints. And most importantly, that they need to be proactive in stopping this inappropriate conduct, and they can't just receive a complaint and say, okay, well, work it out between the two of you. It needs to be escalated and probably pursuant to the company's policy to HR and above the manager as soon as possible.
And as you mentioned, no adverse action taken against someone because they reported. And that applies to the public accommodation context we mentioned as well. A customer who comes in and has a complaint, you don't say, well, all right, get out of here. We're kicking you out now. I'll tell you, Hannah, we've dealt with these retaliation cases. They're often some of the most difficult to defend because if you get in front of a jury, everybody, discrimination is one thing. Not everyone can say they've experienced discrimination, but retaliation, everybody remembers, the playground where they were picked on or they were retaliated against because, they stood up for their friend after the bully stole their lunch money or something. Everybody has this sort of understanding of that unfairness of retaliation. And they can, jurors particularly, can bring that into the courtroom with them. So these claims, it's very important to make sure that you're following the policies and that your managers are trained not to retaliate.
And that you're stressing to your employees that they won't be retaliated against for good faith complaints. So the responsibilities, again, of employees and managers, make sure you're listening to each other and that you're looking for, sometimes we kind of talked about the texts and the emails and the letters, poems, whatever, but there can even be offensive items in the workplace. We've defended cases before where there have actually been physical items that could have been construed as offensive. Look for these kinds of things that are left laying around. Any complaints or even suggestions of complaints that come to your managers or from your coworkers, take them seriously and don't keep it to yourself. Everything should be reported up so that it can be addressed and it can be dealt with.
And that's a great point. And the reporting procedure should have multiple layers generally, because what happens is sometimes, what if the only person you can report to is the person that they claim is harassing them? And this is a bigger problem in small companies where there may be, fewer layers of management. But that case I mentioned earlier where the claim was, the policy said to contact somebody, but there's no phone number. It was a restaurant owner who was off-site, wasn't on the premises. They're claiming their manager was the one to harass them. And if there's no phone number to get in touch with the owner, the employees had nowhere else to go. So the policy said contact the owner, but it didn't say how. So it was, obviously that was a big problem. And
time may be of the essence, and you don't want to wait until the next time the owner happens to be at the restaurant.
Prompt remedial measures are the legal standards.
Right.
So, yeah, that's a huge issue. So but that leads to employees as well, of what to do if they're being harassed, or what to do if you're a manager or coworker and you witness harassment. You mentioned at the outset you could talk to the harasser, have that communication at the outset that you don't feel comfortable. It's certainly an easier thing to do on some of these more thin ice. Hey, look, you're really invading my space. Obviously, the more severe stuff, you have these policies. You're going to go to your manager, a member of the management team, talk to human resources, or any of the above, and the policy should spell that out. Now, one thing.
But what if an employer has a policy that requires a written report?
Well, we've had a lot of those lately, and I don't like it. I think EEOC certainly takes the position that you can't require someone to provide a written report, because what if someone doesn't feel comfortable, or what if they don't have access? What if they only have a phone number, for instance, in that case? Your policy should be broad, that the person should be able to report harassment. There should be mechanisms, email, face-to-face, phone call, letter, whatever it may be, text. but it shouldn't limit them to only one means of communication because it's just not always practical, and the EEOC is going to view that as too narrow of a way to report and that it violates the law. And as a practical matter, you want to have the policy as broad as possible so you know, and then what happens is, from a management standpoint, you should have managers trained that once you do get that report, whatever way it comes in, document it. Put it down in writing, begin your investigation, document your investigation. You don't have to have the written report from the witness. Sometimes they don't feel comfortable, but you can certainly write up what that person says. You can offer that write up to the person to review and sign if they don't want to. You still have a duty to investigate. You still need to go through the process and do your own documentation. But no, you're right. I don't like those policies where it says, only report in writing or don't report at all. Those are problematic.
Right.
But the policy should specify that the report needs to be made immediately. How many cases have we defended in where there's some harassment that was reported, 3 years later,
Right.
and now they're trying to sue, claiming that, there was all, I didn't know, I thought I had to live with it. They didn't tell me I had to report it immediately. And of course, it always happens right after the person gets disciplined or is about to be
Absolutely.
fired. Now, suddenly, for the last 5 years, they've been harassed by their supervisor, and they have to report it immediately. So the policy should definitely clearly say immediate reporting, and through those policies, phone, email, whatever you can do. If you don't have these policies in place, you don't do a thorough investigation, take problem measures, there can be costs. If you're an employee who is accused of this improper conduct, of course you can lose your job. There's damaged reputation for both employees and companies, managers. There's emotional toll, and there's legal liability, money, damages. For supervisors in Michigan, you can be personally liable for discrimination. So, it's not always just the company's problem. Someone can sue you as a decision maker individually. A lot of people don't know that. So it's something that's important to consider. This rule for Michigan was, it used to be you couldn't be, but around 2005 the law changed and you can be individually liable. So it's something to think about, whether you're, again, in that public accommodation context or with your employees. You have the duty to follow these policies, treat everyone fairly, or else, you are risking some potential liability yourself. And ultimately the goal of these policies, the goal of these laws is to create an inclusive environment, to treat everyone fairly. Diversity is appreciated, people feel respected, and everyone, you want to have a happy, healthy workforce that everyone feels comfortable coming to work. That's sort of the goal. And you want the same thing for your patrons, customers who are coming in, that they feel that they're welcome, and your employees as well, obviously. So I think that we'll do a quick pop quiz, Hannah.
Well, let's run through some scenarios. So, Marcus and Sherry were involved in a consensual relationship for over a year. Marcus ended the romance, but Sherry kept calling him and sending him email messages, repeatedly asking him to meet her after work for dates. She also sent him sexually suggestive notes and cards through the interoffice mail. Marcus refused her advances and asked her to stop. Now, let's talk about this. Can a formerly consensual relationship in the workplace ever turn into harassment?
Oh boy, that's like half our cases, right?
Well, the rule is unwelcome harassment, and these are the kind of risks that you run. First of all, does your company have an anti-fraternisation policy? Thank you. If not, and relationships are allowed in the workplace, what happens when the relationship goes bad?
And that's always the biggest risk. The company should certainly have a policy that managers, cannot date subordinates at a minimum.
Absolutely.
Co-workers dating is another thing, and this is where it gets bad. When you see this, they broke up and now they're fighting, or now we have reports against each other because, one person may not be over it, or still, like in this case, sending messages for continued relationship. That becomes a problem that should be addressed. Sexual harassment, you mentioned, the definition is an unwelcome, hostile environment. So during the relationship, you certainly have a legal defense that this was welcome, but we know as a practical matter that in the workplace, people break up, people have fights, and that's where we really have problems.
Right.
Well, another situation then, the guys at work routinely get together to tell dirty jokes and share sexually explicit and derogatory cartoons in magazines, or these days, memes probably, right?
Right.
Kids these days. This behavior is okay in the workplace as long as they do not share this material with the women and just keep it among the guys. What do you think, Hannah?
I think not so much.
Well said. Yeah, that's a problem because it never, first of all, it never really works that way. And if a guy, quote unquote, in the group happens to be uncomfortable, it's still an unwelcome, it can be a hostile work environment. Also, often people overhear these things. We've had cases with people who had actual pornography up on their computer in the workplace, and someone walked by and saw it. Okay, yeah, that's bad. Same thing with these kind of jokes, sharing memes, cartoons. They can get offensive, and it's more and more common these days for people to send these memes or jokes to each other by text or Instagram, direct message, and you just want to be careful.
We talk a lot about jokes. Here, Rob told an ethnically derogatory joke to his coworkers, including Peter, who is a member of the ethnicity targeted by the joke. Everyone laughed at the joke, including Peter. This did not constitute ethnic harassment because Peter laughed at the joke and Rob did not direct it toward Peter. Again, we talked about this earlier, the giggling, the laughter. A lot of times that's often the response when people feel uncomfortable. So that's not a yardstick by which to measure whether or not something was appropriate in the workplace. This is certainly not permissible.
And no, you're absolutely right. It's not, and that's another case where if that is witnessed by a manager or supervisor, it should be addressed,
Absolutely.
even if it's not reported immediately. Well, another situation with Julie posting on social media a complaint of harassment about her manager. It's an off-duty comment, and she doesn't want to pursue anything when asked, but she tweets "Me Too" regarding this manager. So again, now we have the off-duty conduct. It's known, and there's a "Me Too" tweet, which is certainly going to be a red flag to any HR professional. So what do you do? Do you investigate this? Do you ignore it? She had said she didn't want to pursue anything.
Absolutely. You need to investigate. You need to address it.
Still are going to have that duty to take prompt remedial measures. She may say she doesn't want to pursue it, but the company has to enforce its policies, so you're going to investigate that and at least get her side of the story, talk to the offender, and get involved.
And that's really important too. I've had some clients recently talk about that. They have an individual who, a scenario like this comes to their attention, comes to the attention of management, and the employee repeatedly states, I don't want to pursue it. I don't want you to do anything. I don't want you to tell HR. Managers, you have a duty to tell HR. You have a duty to investigate these situations, and you can't promise confidentiality to these employees.
That's a good point. What you say is, we'll keep this as confidential as we possibly can, because, obviously if you're talking to people,
Sure.
There's going to be something coming out. But that's sort of, and policies usually will reflect that. But we've had too many questions from clients where, there might be a perception that if someone says, I don't want to do anything about this, I don't want to pursue it, that, okay, well, maybe we just drop it. No, there's still legal duties there to investigate.
Once they've reported, absolutely.
So a few tips then to prevent these kinds of issues, particularly when in the harassment context. Whether if you're an employee or manager, does it need to be said or done at all? If you're asking yourself of that question, it probably shouldn't. If you're about to tell a joke and you find yourself looking both ways behind you, probably it's going to be offensive. Don't say that joke. Some of this is just the golden rule. How would you feel if someone said or did something to you or someone you loved? If that's something that you think would be offensive, then you shouldn't be saying it to other people. And again, if you feel that any person said or did something, how would you feel, and is it something that you think is bad enough to report, or simply refrain from saying in the first place? For those managers who then receive reports, and it's one thing to kind of avoid it in the first place, but obviously people do crazy things in the workplace, or Hannah, we wouldn't have jobs.
Right.
But managers are going to come to learn some of this stuff, and you want to immediately, as I said, don't force someone to put down a written statement if they don't want to. but you should get all the details you can. Who, what, when, where. Who is accused? What did they do? When did it happen? Make notes. Begin an investigation. Listen with empathy. Don't cut them off, interrupt, or assume, oh, so-and-so would never do that. You have to kind of keep an open mind when you get these kind of reports. Let the person know that you've understood the report. You can give them kind of the feedback. Okay, so I'm understanding that on this date, at this time, so-and-so engaged in this conduct. Tell them, the position. Thank them for bringing the complaint, and give them sort of the next steps. Advise that employee that you're going to work with HR. If you are HR, what you're going to do. We mentioned you can't promise confidentiality, but you can say you're going to make it as confidential as possible, and you're going to follow up through your normal procedures, whether it's human resources, the manager, someone who is tasked with this kind of work, and your policies will follow up and do an investigation. That's sort of just the basics when you get that input coming from an employee. Then, of course, if you're a supervisor or a manager and you may not have, in particularly large organizations, direct responsibility for conducting your own investigation, you need to report it to whoever does. Report it to HR. Do it immediately. When you receive it, when you learn about it, if you've overheard something, kick it up the chain so that you know that someone can take care of it. And again, from a management standpoint, you want to protect your own job and your own potential liability.
And this is where documentation is key. When they come to you with that verbal report, begin making notes, begin documentation, so that when you escalate it up to human resources, you've documented what the information that you have knowledge of and what's been brought to you.
Right. It's not just protecting the company from legal liability. I mean, you have some kind of claim that is obviously severe enough that you feel you have to report it. You should take every step to protect yourself as a manager and the employee who is, perhaps being treated unfairly. Cooperate through the rest of the investigation, whether human resources or someone in management is conducting it. And make sure that truthful statements are documented, witness statements are gathered. Cooperate however you can as a manager. You'll also have duties, of course, as a manager during the investigation. We've mentioned confidentiality, but retaliation at this point becomes the big issue because, Hannah, you mentioned, I think, pretty clearly, you got to have some policy and remind employees when they report that there's anti-retaliation provisions, that you're not going to do anything against them. Thank you for bringing this to our attention. We're not going to take any adverse action. But again, a lot of times there are things going on with this employee. Sometimes people report, as we said, only when they're on their last chance at work. But you need to make sure that you're coordinating with human resources or management to ensure that you're not retaliating, that whatever actions come next, you're following the law. Absolutely. And the policies. So a few summary points. The stakes are high. There's a lot of cases in the news. There's Me Too. Sexual harassment is obviously a big one. Racial, religious. There's always something. Whether it's Abercrombie a few years ago was sued for banning headscarves from their employees, or whether it's a Me Too movement type case. I mean, this is in the news. Employees know about this. Drive down the street, you see billboards. Have you been harassed at work? Call Gold Star Law. Employees are aware of these things. So the stakes are high. There's potential liability. And no matter where you're located, if it's Michigan or other workplaces, there is a potential lawsuit. There are administrative agencies that kind of regulate and enforce these rules, and there's always a potential court and jury at the end of the day. So it's one of those things that there was a recent joke going around, like dance like no one's watching, and send your emails like it's going to be read aloud in a deposition, and that's pretty true. Yeah. Because something seems very funny, but when you read it in a written, dry transcript after an attorney's been cross-examining you, it might not be so funny anymore.
Right. Great point. All right, so let's go through a little pop quiz here. Let's start with first one. Sexual harassment only involves asking others for a date or for sexual favors in return for promotion or other benefit. Well, it's certainly correct that these things would constitute sexual harassment, but they're not the only things that constitute sexual harassment, right, Brett?
There you go.
We've discussed lots of other scenarios that could
There,
constitute.
yeah.
Sexual harassment can only occur between a man and a woman. Well, absolutely not. Entirely false.
Yep. No, we talk, and we have cases in our area, in our jurisdiction, quite frequently on same-sex harassment. We mentioned the LGBTQ component, but there are cases where it doesn't
Sexual
have to
orientation may not even be
exactly. It's
relevant.
not even. It's just someone. It's horseplay between two guys that gets. I mean, some of the cases are really severe,
Absolutely.
like physical assault kind of thing. And just because it's between two men who are straight doesn't mean that there's no liability there. So that's a great point.
All right, next, sexual harassment is the only type of illegal harassment that can exist in the workplace. We know that's not true. Brett talked about lots of other different types of illegal harassment that can occur. But again, because we hear so much in the news these days about sexual harassment, that just seems to be forefront in everyone's mind. An employee can be legally disciplined for engaging in harassing behavior in the workplace, up to and including immediate discharge. What do you think?
Absolutely. And in fact, there's as we mentioned, a legal duty to take prompt remedial measures. So that means if you have a harasser and you've confirmed harassment, you need to get them out of the workplace. Fire them.
Any act in the workplace that another employee is offended by is considered to be illegal harassment in the workplace.
That is false. The rules in your policies do not create a workplace civility code, but
That's a great point.
The thin ice kind of comments we discussed, when you see professionalism issues tipping that balance into protected categories, something about someone's race, religion, sexual harassment issues, that's where you definitely need to start the investigation, be concerned.
Right. The alleged harasser cannot be held legally responsible for the harassing conduct. Well, we know this is absolutely false.
That.
All right, prevention is the best way to reduce or eliminate harassment in the workplace. Definitely true.
That's why people are watching this right now.
That's right. And once you've been involved in a consensual relationship with a coworker, you can never be accused of harassment by that coworker. We discussed this. We looked at examples of this. We know that's false.
We're defending cases with that right now.
We are.
That's a common one.
I can make any type of comment I want at work because I have the right to free speech. Oh boy, we've probably heard this before.
We get this all the time. Yeah.
This is false.
Yeah, when you're a private employer, there is no free speech right that anyone has in the private context. There is free speech for government employees, but again, it can't be hate speech or discrimination. So don't let that be one of the excuses you hear in an investigation.
Right. My coworkers cannot claim I harassed them just because they overheard a conversation I had with another person. This is false. This is an important point too.
And I mean, it goes beyond that. We've dealt with associational discrimination, retaliation cases where someone may report on behalf of that coworker who perhaps they overheard being harassed and claims that they were then fired or something happened and demoted. And they can state a claim because even though they weren't, perhaps they weren't harassed or feel offended by it, but yeah, they have a retaliation claim, associational claim now.
Sure. All right, and the last one should be easy for everyone. Everyone has a right to work in an environment free of harassment. Absolutely true.
That's right. Unlawful harassment. I guess that is a point, Hannah, because we get a lot of employees who throw the word harassment around.
That's true. Yeah.
But it's really like, someone took the turkey sandwich out of out of the fridge for lunch and stole my pop, and that's a harassment. I'm going to sue you. It's, okay, no, that's not on these protected categories that we've talked about.
Right.
Okay, so with that, I want to take a moment here to thank Brett and Hannah for the presentation. Thank you very much. And also thank everyone who attended today's presentation. If you have any questions, please feel free to reach out to Brett or Hannah. Their contact information is up there on the screen. And everyone have a great afternoon. Thank you.